conversation. I'm going to have greater clarity about what I think. We are doing this with Residential Life and Housing. I want to introduce Keisha Saran, who is the resident director in Housing and Dining. And she is going to introduce our speakers. The format is we're going to invite the speakers to open up. And by the way, when the pizza comes, you can just quietly, these folks won't be disturbed. If you want to quietly get up and grab another piece of pizza, or if you haven't had any pizza, your first pizza. We'll put the pizza where? Right here? We'll put the pizza right here. Just come on up, not to worry. So the format, we'll start out, they'll open up with 10 minutes or so of presentation, and then we'll have a conversation. We'll try to get to the bottom of this. We'll try to figure out what the heck is going on. And again, thank you very much for coming. So, Keisha.
So like Joe said, I'm Keisha Stram, I'm a resident director for Let's Clark and Roper Halls. I am co-sponsoring this on behalf of the Social Justice Living Learning Community in Roper Hall. So if you are a residential student, definitely come by and see me after this event is over. We do have $5 for all students who attend that can be used on both sides of campus at our $5 initiative. Without further ado, I do want to introduce our two panelists that are here to speak a little bit on their experiences as it relates to our topic today. So introducing Carrie Corderero. She is the director of the National Security Studies at Georgetown University Law, and she's also an adjunct professor as well. She received her BA at Barnard College in Columbia University, and then her JD at American University, the Washington College of Law. In November 2011, Ms. Corderero joined Georgetown Law as its first director of National Security Studies. Previously, Professor Corderero served in national security-related policy and operational positions with the Department of Justice from 2000 to 2010, and most recently as the counsel to the Assistant Attorney General for National Security. In this capacity, she provided counsel for on the National Security Act, the U.S. Patriot Act, and other relevant laws and executive orders while serving as a co-chair of an interagency group developed by the Director of National Intelligence. Additionally, she's previously served as an attorney advisor in the former offices of Intelligence Policy and Review at the Department of Justice, where she worked with the FBI and other intelligence community agencies on critical counterterrorism and counterintelligence investigations. She also has served as a special assistant to the United States Attorney in the Northern District of Texas. And prior to joining the attorney staff, she was of the Department of Justice through the Attorney General's Honors Program. She's recently been selected as a 2013 participant in the Women in Technology Leadership Foundry, an initiative that prepares women executives for board service. And introducing to her right, Stephen Vladeck, a professor of law and associate dean for scholarship at the Washington College of Law here at American University. His teaching and research focuses on federal jurisdiction, constitutional law, national security law, and international criminal law. He's a nationally recognized expert on the role of federal courts in the war on terrorism, as he was an integral part of the legal team that successfully challenged the Bush administration's use of military tribunals at Guantanamo Bay. He's co-authored party and amicus briefs in a host of other major lawsuits, many of which have challenged the U.S. government's surveillance and detention of terrorism suspects. Additionally, he's won awards for his teachings, his scholarship, and his service to the law school, and has previously, as a graduate of Yale Law School, clerked for Honorable Marcia S. Berzon on the U.S. Court of Appeals for the Ninth Circuit, and Honorable Rosemary Barkett on the U.S. Court of Appeals for the 11th Circuit. So I'd like to turn it over to the two of you, and we can begin our discussion.
Am I going first?
Go ahead.
All right. Great. So hi, everybody. Thank you for coming. Thanks to Joe for setting this up and for inviting us. I want to start by basically giving, I think, a couple minutes of overview of how we got to where we are today, and then try to suggest that traitor or patriot is actually not the right question, and that I think it's actually a bad sign of American discourse when we think that that's the only question that matters now, coming on 9 months after Edward Snowden's disclosure. So let's start at the beginning. So back in June, there were a series of fairly sensational front-page newspaper articles revealing hitherto secret government surveillance programs, thanks to leaks by Edward Snowden, who was a former NSA contractor who had leaked all this information to a series of reporters led by Glenn Greenwald at The Guardian, Bart Gellman at The Washington Post, and an independent journalist named Laura Poitras. And the three of those journalists together had basically written a series of stories that published on the front pages of these newspapers the most intimate details of some fairly significant US government surveillance programs. Among the things we learned from these disclosures was, for example, that under Section 215 of the Patriot Act, the government had been collecting in bulk the so-called metadata, basically the non-content information from virtually all Americans' phone calls. We learned that under the so-called PRISM program, run through Section 702 of something called the FISA, Foreign Intelligence Surveillance Act Amendments Act, that the government had basically been collecting on a mass scale content of communications outside the United States on the ground that they were reasonably believed to involve non-citizens located outside the United States. And we learned a whole bunch of, I think, less headline-worthy but equally revealing things about the role of the secret Foreign Intelligence Surveillance Court in approving these programs, about the sort of lack of real pushback from Congress, whether because they didn't know about these programs or because they didn't care. Carrie and I think, disagree a little bit on which one of those it was. Right, and we learned that basically these programs had been allowed to expand rather dramatically over the course of the last decade with very little public awareness and with very little pushback from the mechanisms that had been created to oversee our foreign intelligence surveillance activities. Whatever you think of that, right, the person at the center of this story is Edward Snowden. Snowden, as we probably remember, fled from Hawaii first to Hong Kong. And then after an attempt by the U.S. to extradite him didn't go so well, Snowden ends up relocating first to the International Arrivals Building at Sheremetyevo Airport in Moscow, and then eventually he receives 1 year temporary parole status from President Putin, although one has the sense that that 1 year is renewable. And this leads to a series of calls in the United States to bring back Snowden, to indict him, to prosecute him, and so on. It actually now appears, thanks to yet another leak of national security information, that there actually has been an indictment obtained against Snowden in federal district court in Virginia for his disclosures. And so there are really two very different conversations. The first is Snowden, yay or nay, right? And the second is how about the things Snowden has disclosed? What should happen as a result of these disclosures? And what I want to suggest very briefly is I actually think the first conversation is much less important than the second one. Right? That is to say, Snowden is not the first person to leak highly classified national security information to reporters. He will not be the last person to do it. And, you know, as for whether he's a traitor, I know some of you raised your hands. Let me, the constitutional law professor, try to convince you that traitor is a legal term. And not a philosophical one, and it is used to describe someone who has committed the crime of treason. And treason is a specific intent crime. For those of you who aren't law students, what that means is it's not just if you do something by accident. Treason is specifically intending to cause harm to the United States and or benefit a foreign power by levying war, right? By actually taking hostile acts, either for the foreign power or against the United States. There's no question in my mind that what Snowden did damaged our national security. Whatever you think of his disclosures, it is certainly the case that our foreign intelligence surveillance activities are easier to hide from foreign terrorists if they don't know about them. I think that's just an objective fact. But whether he's a traitor is not the same thing, right? To me, traitor means has he committed treason? There's no evidence of that, and indeed, the indictment the government obtained against him does not include a treason charge. Is he a patriot? Well, that's harder. And I don't think anyone can tell you what the answer is. That is to say, right, whether he's a patriot is, to my mind, a moral judgment. A moral judgment that has little, if anything, to do with whether he followed or broke the law. How many of you guys have crossed Massachusetts Avenue against the light? Or not at a crosswalk? Yeah, those of you who are not raising their hands, I don't believe you. Right? There's a very big difference in our society between being law-abiding and being morally righteous. And so what I want to suggest to you is not that you should believe that what Snowden did was morally righteous. What I want to suggest to you is that it's up to you, and not what people tell you. So let me offer two possible theories about why he either is or isn't morally righteous and therefore potentially a patriot. On the pro-moral righteousness point, one could argue that Snowden's disclosures have actually meaningfully advanced public discourse on any number of questions of significant public concern. No less a figure than President Obama has now said on the record that we as a nation are better off for the series of conversations we've now had about foreign intelligence surveillance thanks to Mr. Snowden. You can think that even if he broke the law, he did it for a good reason, which was to illuminate the potential illegality behind at least some of these surveillance programs. You could think that his motives were actually relatively pure, which is to say he really just was trying to get the news out there, and that there was no way he could have done that through any of the available bureaucratic channels available to him, for example, by going to talk to the NSA's Inspector General or other internal officials. After all, these programs had been signed off on at the highest level. So that's sort of the key elements of the pro-Snowden meme. There's an anti-Snowden meme, and it goes, I think, a little bit like this. First, there's no question that he caused serious harm to the United States and benefit to foreign powers, especially China, Russia, and terrorist groups who are now using alternative ways to communicate with each other. Second, unlike other notable figures who have been morally courageous when they broke the law, Snowden ran away. Right? So as opposed to, say, someone who breaks the law and goes and raises the defense in public in court, Snowden left. Query whether you would do that if you were in his position, but it's part of the argument. Third, given where he went, that is to say, given that he went to Hong Kong first and now Russia, there is at least the appearance that he is cooperating with the foreign powers who stand to gain the most from the information he's disclosing, who stand to benefit the most from learning about how we conduct our foreign intelligence surveillance activities. And that at least smells funny, even if it isn't actually true. And I think fourth, and probably perhaps most importantly, Snowden didn't actually avail himself of the bureaucratic channels available to him. He didn't actually go to the Inspector General, even if that would have been futile, right? He didn't go to his congressman. He just went straight to the press. So I don't want to suggest that either one of those narratives is correct, right? Because I think when it comes to moral judgments, there's no such thing as a clearly right or clearly wrong answer in this context. What I want to suggest is that it is a judgment for you as informed citizens to make, wholly irrespective of whether Snowden did or did not break the law. Because if the question is whether Snowden is a criminal, the answer is yes. There's a federal statute called the Espionage Act. For better or for worse, it clearly prohibits, in 18 U.S.C. section 793D, the disclosure of classified information that to individuals who are not authorized to receive it, if that information is something that the disclosee knows or has reason to believe will benefit a foreign power or will harm national security, regardless of their intent. Now, there are lots of reasons to not like this statute, but it's been on the books since 1917. It's been used at least 9 times to prosecute national security leaks. And we can talk about this later, but I doubt you'll find the First Amendment is that much of a defense for a government employee in this context who leaks information. So to sort of wrap it up and open it up to Carrie, let me just say briefly, Snowden is not a traitor. Snowden is a criminal. And as for whether Snowden's a patriot, that's up to you.
All right, super. Thanks, Steve. Thank you, Joe. Thanks for having me here today. It's a real honor to be here, particularly as an alum of AU's Law School. Nice to be able to come back on campus and get to be here with you all. I'm hoping, I'm going to offer sort of a few follow-up remarks to Steve's, but really I'm hoping that this can be very interactive because this is really a great group. And so I'd like to, have a back and forth and have Steve and I sort of participate more in a conversation with everybody here as opposed to us just sort of talking at you for a little while. So I hope that we can have a nice conversation as we go forward. So a few thoughts. I tend to agree with Steve that although it is sort of a good soundbite, the traitor versus patriot, I think really if the question can be turned a little more accurate of the question would be, is he a whistleblower or not? So sort of take the treason part out of it. Is he a whistleblower? And lots of academics have written on sort of what is a whistleblower, and there are sort of the whistleblower context in the corporate world, exposing fraud and abuse and things like that, and then there's the whistleblower in the national security context. But generally, when we think about a whistleblower, we think about somebody who is an employee. In this case, we had a government contractor who has either revealed information that is a demonstration of illegality or some kind of abuse. And you may have sort of additional thoughts about what plays into it. But that's sort of how I think about what's a whistleblower. And so as we think about Edward Snowden, and we think about whether or not he fits into at least that category, a few thoughts to offer. So one, on the question of whether or not he has actually revealed any instances of abuse. From my perspective, and just to give you a little bit of a framework, so I'm at Georgetown Law now, but I was a practicing national security lawyer in the government. And so I practiced before the FISA court, the Foreign Intelligence Surveillance Court, worked on counterterrorism and counterintelligence investigations, and was involved in a lot of the oversight and compliance mechanisms of the surveillance activities, some of them that are sort of out there and being discussed now. So whether or not he revealed instances of abuse, from my perspective, the answer in terms of what's been disclosed publicly is no. I don't think there's anything that has been revealed either through what has been reported regarding information he's leaked, or even information that the government has subsequently declassified, that shows that the government was doing any type of strategic, deliberate, inappropriate monitoring for political purposes or anything like that. What has been revealed is that there were compliance problems, which we can talk about later if that's of interest, and compliance incidents, which are contemplated by the Foreign Intelligence Surveillance Act. But I don't think there's anything on the record that has come out that indicates that there's any kind of deliberate abuse, targeting of people for inappropriate reasons, vendettas, political targeting, when people think about sort of the types of abuses that we know occurred in either the 1960s, 1970s time frame. So then the second question becomes, has he revealed information that activities on the surveillance front are illegal? Again, from my perspective, the two main programs that have been discussed the most, which are the telephone metadata collection program, and then what's been called the 702 program, which is content-based collection of targeting foreign persons who are outside the United States. From my perspective, and I think there's a good record of this, both of those programs are also on solid legal footing. But that has generated a debate. And so certainly there's a public debate, there's a debate in the press, legal academics and so forth. There is some debate as to whether or not, particularly on the phone records program, whether or not that was on solid legal ground. At the end of the day, my own view is that it will show that those programs are on solid legal footing, and we can talk about that more if that's of interest. So putting those two sort of categories aside, a question that comes up a little bit more broadly then is how the government can conduct these types of surveillance activities in secret with the public being comfortable. Because obviously what's happened since the leaks is that information has been revealed because it was previously classified information. A lot of people were surprised at certain collection activities that were taking place. And yet now, as a result of these leaks, senior leaders of the intelligence community have said that it's very damaging. And so actually, as a result of these leaks and this information being public and this public debate, the country is now less safe. And that's a real legitimate concern, that the leaks themselves and the public debate that's being held is actually decreasing the government's ability to collect information that would protect us from a terrorist attack or some other kind of national security threat. So I think I'll stop there, and maybe we can, sort of get into things a little bit more.
Yeah, I mean, let me just offer one more maybe comment before we throw it open to discussion, which is, I think Carrie's right to sort of to put this into the context of whistleblowing, but there's a hard question here, which is to say, the metadata program is a great example. People are really divided, right? Even the legal experts are divided about the legality of the metadata program in two respects. The first is whether it's actually what Congress had in mind when Congress enacted the relevant statute back in 2001. Did Congress really think that this is what it was going to let the government do? That's what we call the statutory argument against the program. The second is, even if so, what about the Fourth Amendment? Do Americans have an expectation of privacy in their phone records, in the metadata in their phone calls? And there's a Supreme Court decision from 1979 called Smith versus Maryland that says that the answer to that question is no. But Smith is older than I am, and older than I suspect many, if not most, of the people in this room. And there's at least one district court decision now that says Smith has outlived its usefulness. Smith is a product of a bygone era when we didn't live in public, when my iPhone wasn't generating the amount of metadata and content data that it generates on a minute-to-minute basis. That hasn't been resolved yet. I mean, the Supreme Court had a case a couple years ago called Jones about the ability of the police to use GPS trackers without a warrant, where the justices said, this is actually a really hard question. We don't know how, if at all, we're supposed to apply these old Fourth Amendment doctrines to new technology. We don't have to decide in this case, but we will have to decide eventually. And interestingly enough, the metadata program raises that question. Carrie's right to say, as I think she said before, if not in these remarks, that there's plenty of authority in support of the proposition that the metadata program is illegal. But then that begs the question, even if it's legal, do the American people have a right to know of what kinds of programs are being carried out in their name? To take another example, right, one of the things we learned about from Snowden, or at least indirectly from Snowden, was what has now been called Merkelgate, that we are spying on the private communications of foreign leaders, including Chancellor Merkel. So from a legal perspective, there is absolutely no question that the government has the power, when it's conducting foreign intelligence surveillance, to surveil foreign leaders. I mean, if anything, that's where the money is. And yet, perhaps it has diplomatic consequences, right, that the American people might care about when it comes to election time. So the hard question, I think, about Snowden's disclosures, separate from the question Carrie rightly raises about the infrastructure of oversight and accountability for secret programs, is to what extent does and should the public have a right to know about programs that might be legal, but that would be controversial? All right, that's to say, programs the government clearly has the constitutional authority to undertake, but that if the people knew about them, they might not approve. And here's the paradox. How can you have meaningful, popular accountability for secret programs? Right? If you're educating the people sufficiently to allow them to have an informed judgment about whether or not they support a program, you're also educating the targets of the program. Right? And so the real, I think, question that Snowden's disclosures have raised is there a way to split that baby? Is there a way to have meaningful democratic accountability and oversight of secret government surveillance programs? And if so, do we have that today?
Okay. Well, so to pick up on that, so here's the balance that was struck. I mean, here's the way it's supposed to work. The way it's supposed to work is that after the 1970s, when FISA was passed in 1978, other things were reformed in the government too, so that there was accountability to the people. And one of the there were sort of two major things that happened at that time. One was the passage of FISA and the creation of the Foreign Intelligence Surveillance Court. The point of the court, which we're the only country in the world that has a foreign intelligence surveillance court that actually approves the executive branch's requests to do foreign intelligence collection. Every other country in the world just does this under their version of the executive branch, executive power. But we have a court that approves it, and there's a statutory rules, and so the government has to go make a case to the court and under the statute get approval to do it. That court was created to do its business in secret, because there was also a recognition during the legislative debate of the creation of the court that if a government wants to collect foreign intelligence information, it can't all be out in the public. Otherwise, there's not going to be much value in that collection, which is what I suspect is a little bit of the position going on now after all of these leaks. So one major institutional organization that was created specifically to provide sort of confidence by proxy was this creation of a court that's supposed to be it's an independent judicial branch. These are real district court judges who sit on this court. They have independent judgment, and they are supposed to approve things in the classified context, and that is supposed to provide confidence to the public, just the knowledge that that court exists and is involved in the process. The second sort of major institutional component here is Congress, and specifically the creation of the intelligence committees in Congress that were specifically created to conduct oversight of the intelligence community, not have the information that is known to them be known to all of the members of Congress or to the public. But again, these are elected representatives who sit on these committees, who have access to all of the information from the government about these types of programs, including the programs that have since been leaked. The members of the Congressional Intelligence Committees have known about them since their inception. They receive lots of reports and briefings and all sorts of FISA court opinions and all sorts of information from the executive branch so that they, in their capacity as elected representatives, can be knowledgeable about and know about these activities. So those were some of the institutional things. I think what we have found, and I think to some folks, including my own, a little bit of surprise over the last 8-9 months, is the fact that that system of oversight doesn't seem to be giving the public confidence. So in other words, when the leaks came out and the government can come out and say, well, but members of the intelligence community knew about it, the court was involved, and so on and so forth, that doesn't seem to have stemmed the concerns that some folks have about these issues.
Well, and I think so I think that's exactly right, and I want to suggest two reasons why. Right, and so the first reason why I think the public hasn't been assuaged, right, by these mechanisms, is it's important to know about the FISA court, the secret court. It is true, they're federal judges, they're district judges, handpicked by the Chief Justice to play this special and unique role. But there's been one really important shift in what they do since 9/11. So before 9/11, the job of this court was basically to handle individual cases. So they would come to the government, lawyers like Carrie would come to the FISA court and say, we have probable cause to believe that Joe is an agent of a foreign power. Rightly or wrongly, right? That would be the question. And there would be ex parte, so one-sided, in-camera, secret proceedings, where the court would basically look at the government's evidence and sign off on only that question. Was there a probable cause? This is what happens all the time in the ordinary criminal law enforcement context. Right, the government, one-sided, goes to a judge, says we have probable cause to believe that Steve is involved in a crime. Therefore, we'd like a search warrant. Right, that's actually pretty typical. The only difference in FISA is that it was secret. Right, that I, as the suspect, would never know until and unless evidence obtained through that search was used against me in a criminal prosecution. What changed after 9/11 is now the FISA court is not just asking, is there probable cause to believe Joe's an agent of a foreign power? Now they are administering wholesale, systematic mass surveillance programs. The collection of phone records under Section 215 requires no individualized showing. The government doesn't say, we believe Joe is part of Al-Qaeda, therefore we want his phone records. The government says, we believe that if we have everyone's phone records, we can figure out who's part of Al-Qaeda. Now that's a little bit of an overstatement. Carrie can probably explain why that's not quite what's happening. But there is no individualized determination by the FISA court. And yet there's no one on the other side. Right, now that it's this mass scale systematic thing, Congress, when it created this authority, specifically provided for the recipient of these orders to show up and to argue against it. No one ever has. right? No recipient of a metadata order has ever actually availed itself of that opportunity. So I think that's actually a fairly important change in the oversight mechanism, right? That Americans who are sufficiently read up on this stuff are uncomfortable with the idea of such basically administrative law being conducted in one-sided, non-adversarial judicial proceedings. And I think that's part of why you're seeing a lot of support in Congress and from the president now for the appointment of some kind of special advocate to argue as basically the other side in the FISA court. Security cleared lawyer, he would do it in private. He would not then go up to the front steps of the courthouse and tell everybody what he did, but that would at least be better. As for the oversight committees, I mean, Carrie's exactly right that the intelligence committees were initially designed to play this function. But there are two problems. When Carrie says the members of these oversight committees knew about all these programs, what she really means is they had access to secure compartmentalized information facilities where somewhere in a drawer was information about these programs. Right? There weren't full briefings of all the elements of these programs. The rest of Congress did not necessarily have access to this information until particular points in time. And leaving that aside, if you think that the intelligence committees were created to basically be the check, to be the skeptics, I think it's telling that, in fact, the intelligence committees are the most ardent defenders today of what the government has been doing. And I'll just give you one example of this. And this is, I mention this only because this is my claim to fame and I will never do anything nearly as famous again. I was on the Colbert Report. Totally by accident. I was the foil because I had the privilege of testifying at a House Intelligence Committee hearing in October. And Chairman Rogers, this is the chairman of the House Intelligence Committee, the all-important oversight mechanism, is trying to figure out why no one had ever complained about these programs. He says, I think it's telling that in the 10 years we've had this program, no one's ever complained about it. Well, I, being the asshole that I am, interrupted him and said, but who would be complaining? Since we had not known about these programs until Snowden came along. At which point his response is, well, your right to privacy isn't violated if you don't know about it. And this is not just some random member of Congress. This is the chair of the Intelligence Committee. This is, by any account, no less than the fourth most important oversight official when it comes to congressional oversight of intelligence operations, and that's his mentality. So, when Carrie says it's worth asking why we've lost faith that the secret FISA court and the secret behind closed doors proceedings of the intelligence committees are sufficient checks on what the government's doing in our name, I think those are pretty convincing answers for why at least some of us have lost faith.
So, so 2 quick points, and then I want us to open it up. So, but there's maybe 2 things that I do want to respond to. So one is, I think it's an overstatement to say that the information provided to the intelligence communities is simply stuff that's in a drawer somewhere and they can go find it if they want. I disagree with that sort of characterization of it because
even though there are members of Congress who have offered that characterization.
First I'm going to just on the Intelligence Committee. So focus on the Intelligence Committee.
Right. Congressman Schiff is on the House Intelligence Committee, and he has said on the record that he did not have briefings on these programs.
Well, the members. My experience in government is that if members of the intelligence community wanted to request a briefing or wanted to go up to NSA to learn about these programs, they sure could. And that was my experience.
So they had to affirmatively request a briefing about something they didn't know about.
No. So first of all, there are, under the statute, there are lots of very, very dense written reports that are provided to Congress. They're very informative, these reports that are provided to the that are provided to the intelligence committees. And all the members of the Intelligence Committee can read those reports. Those reports are also provided to the members of the Judiciary Committee, and they can go and they can read all of those reports. They're available to them to go read. There are also lots of different briefings that are scheduled at different times. Some are sort of official briefings by heads of agencies and components and so forth. Some are lower level briefings that are provided by sort of lower level government, mid-level government officials, things like that. But there are a lot of briefings. In addition to that, particularly during sort of these years of the compliance incidents and things like that, there were additional briefings that were provided to members of, again, the intelligence committees. And there were lots of opportunities, I would say, for members of the intelligence committees to be briefed by NSA and about these particular programs. Now, the issue of Congress more broadly, when you get outside of the intelligence committees, that is a little bit different issues. Over time, there have been certain circumstances where all members were invited to certain briefings to learn more about programs. Those sort of occurred occasionally. There has been some debate about what the accurate record is as to whether all members of the House, for example, were invited to read certain information. There is a record that all members of the Senate were invited to read certain information. So but the role of the intelligence committees, I don't think that one can legitimately say that the intelligence committees were not in a position to be accurately informed. I would disagree with that. But can we open it up?
You can certainly open
All
it
right.
up. I've got some questions. I know you have questions, and this is one of those golden opportunities where you don't have to disguise your comment as a question. You can make your comment, but you just have to keep it short because we have a lot. It's a
boring topic.
We have a rousing conversation going on. Let's start right back here. Yes, just say who your name and your student. I presume. I'm assuming.
John David Clark. I graduated recently out of the master's program here at SIS. I think in terms of abuse, I think the memory in America is of like Herbert Hoover and stuff like that. Every time the government has had access to lots of information, it's never been used for good purposes, and it's used not for the big.
Hoover, not Herbert.
Yeah.
J. Edgar Hoover.
Sorry, not Herbert Hoover. So
If
FBI
only Herbert Hoover had used all that information.
But it was used to undermine people that, like the civil rights movement, stuff like that. And we see similar programs now in the U.S. where there was the one in New York City where there was mosques being monitored by the police for a long time. And it was just entrapment, and they never once had a suspect actually had any crimes, but people ended up in jail for it and are still in jail for it because they were entrapped by questionable things. And this is not exactly the same program, but this is related. Having this reach, this such an extent of reach into people's lives, the power always gets abused, and we have a strong memory of very well-documented abuse, how it has always been abused in America, and that's why we're uncomfortable with it. But we have seen
Can I
abuse,
take
and
a
there are
couple of
examples of abuse.
We're going to take a couple of questions. Just
Sure.
you all note down the questions. Greg.
Hi, my name is Greg Ivers. I'm a professor of government in SBA, and this is really great timing, as I mentioned to you before, because I'm teaching this stuff right now, next week in my class. I know it's really hard to transport time because one of the messages I try and tell my students is that, as a political scientist, that decisions are a product of their time. They're not just looking at rules and analytically going back. But to the best of our ability, if this is somewhere in late May, June 1971, and we're talking about Daniel Ellsberg instead of Edward Snowden, I'm curious, Carrie, what your position would be on Daniel Ellsberg. Is he acting beyond where he should be? Would he be someone that we would welcome as a whistleblower? And again, we look back and we look at decisions and we know that probably no one would be thrown in jail for dropping leaflets off a building saying, don't enter the draft. I don't think that would happen in 2014. So Schenck, Abrams, those cases are artifacts. But where's Daniel Ellsberg in this discussion? Do we put kind of the portrait of whistleblowers, do we put Snowden up by Daniel Ellsberg, or is there a difference? For either
So
one.
just- Hi. And stand up and speak loudly so we can get it.
Okay, my
captured.
name is Kim Weichel. I'm not
Yeah.
a student here, by the way. So I was wondering, given the public outcry ever since we've learned about the Snowden leaks and the NSA surveillance, I'm wondering what changes are being made to better balance, well, firstly, expand the small intelligence committee or community that knows about this and can make decisions on it, but to better balance the government's need to do surveillance with the public's right to know.
Good. I think we'll take these three, then we'll come back. Remember your question or comment, and we'll come back.
I'll take that one first, and then you would do the
Sure,
last first?
sure.
Okay. All right, so with respect to changes, so there's a lot pending in Congress right now. So after the leaks,
27 bills.
something like that, yeah, probably and counting. So there's a lot pending in Congress. In terms of sort of how that's going to play out, I had the and this is just my sense of it, in the fall there seemed to be a lot of movement and sort of aggressive march forward, and it looked like there potentially was going to be congressional action. And the proposals are sort of all over the place. So if I can put them into sort of a few categories, there's proposals pertaining to the phone metadata program, ranging from shutting it down altogether legislatively to modifying it in some way. And the modification actually would be sort of, I think, ratifying the government's ability to do it. So it actually would make the statute clearer that the government could collect this information in bulk. But then I think there would be more sort of rules, perhaps rules that are currently in the court orders, but put that into law. So there's sort of competing proposals there. Then there are proposals, Steve sort of talked about this a little bit, to add adversarial process to the FISA court. Some sort of other side that could argue against what the government is proposing to the court. And again, I would place these into sort of two different categories. One proposal is to have an institutional office of special advocate, almost like a public defender's office that practices before the FISA court, where it would be an office, sort of permanent staff, could insert itself into cases and proceedings. The former presiding judge of the FISA court has expressed publicly that that would be undesirable from the judicial branch's perspective. In fact, he has said that it would be, that it's both unnecessary and could potentially be counterproductive to establish that institutional advocate, because it might slow things down and actually sort of get in the way of the court's business. The competing proposal is to what's sort of referred to as the amicus proposal, basically put into law that the court, at its discretion, could appoint some sort of outside expert with appropriate clearances to come in and give another view on a particular matter that the court thinks it would be helpful to have a view on. And that could be an issue that is sort of novel in terms of the legal interpretation, or novel in terms of the technology that might be involved. And then another sort of bucket of proposed reforms is transparency. So can there be more public reporting on intelligence programs and activities that go before the FISA court? Can more FISA court opinions, for example, be made public? So those are sort of different categories of proposals. My own view in terms of the legislative debate, there were a lot of hearings this fall. I think there have been sort of even more recent hearings. There's all of these bills. The feeling that I have, and you might disagree, since the president's January 17th speech and policy directive, where he's himself is implementing some changes, is that the legislative action perhaps has slowed down a little bit to see how his internal reviews sort of finish out, see what more changes he might make in terms of implementing his January 17th policy directive. And then a little farther down the line, we have this looming deadline of June 2015, which is when some of these statutory provisions will sunset. And so that will require congressional action as we get closer to that time.
There's also, there's a shorter deadline, which is the end of this month, for the intelligence community to report back to the president with what they would need the metadata program to look like to be effective, so that the president can figure out which legislative proposals he'd support. Carrie's got it basically right. I would just add there's one intermediate special advocate proposal, which I think comes in between those two models, which is to have special advocates as basically, there's something in criminal law called the CJA panel, which is private lawyers who are specially qualified for certain kinds of cases. So they have their own practice, but they're called upon by the courts in specific contexts. And then the idea would be that you'd have an adversary only in those post 9/11 FISA cases, where the FISA court is doing something other than individualized probable cause determinations, which I think would go a long way toward alleviating Judge Bates's concerns about volume.
Or it might create a little bit of a cottage industry for law professors and outside lawyers who are knowledgeable in this area.
Maybe. As opposed to internal government oversight lawyers. I think, so there's, the larger point I think is the sort of the dichotomy between closing the barn door after Edward Snowden got out, which is fixing the metadata program, and the law and questions of sort of institutional reform. And what's interesting is for reasons I think are obvious but unfortunate, the Snowden conversation has dominated the hearings, the headlines, et cetera, whereas I think the far more important conversation is the structural reform conversation about the relationship between the intelligence community, the oversight committees, the FISA court. Whether you agree with me or not, I think that's much more important as an issue in the long term than any single surveillance program. As for the first two questions, which I think actually have a lot in common about history and Ellsberg, I mean, I think it's important to appreciate that we actually have learned some lessons from history. That FISA itself, the Foreign Intelligence Surveillance Act, is a really important step in curbing some of the abuses of J. Edgar Hoover's FBI, of the CIA pre-1975, right? That the whole idea behind FISA is to interject more law and more oversight and more accountability into this exact conversation. There will always be a bigger mousetrap. I mean, there will always be compliance incidents. That's what Carrie is referring to. I think the compliance incidents are far less troubling to me than the extent to which these very carefully calibrated oversight mechanisms haven't done what I think they should have been doing for the last 10 years. But I think it's so I think we actually have learned some of the most important lessons from that history. I think we haven't perfected it yet. And as for Ellsberg, I mean, the really important thing to remember about Ellsberg is what Ellsberg disclosed in the Pentagon Papers wasn't illegal. Right, so if the view is that when he disclosed all of the stuff about very highly important, highly sensitive, perhaps embarrassing internal conversations about policy toward Vietnam, but there were no disclosures of massive war crimes in the Pentagon Papers. There were no disclosures of massive government illegality. And so if we actually have come to the conclusion in retrospect that Ellsberg was a whistleblower, what was he blowing the whistle on besides the politics of the Vietnam War? And if that's appropriate for public disclosure, why would the legality of the program Snowden disclosed be dispositive of whether he's a whistleblower, right? So I guess it comes back to Carrie's point about whether we view whistleblowing as simply exposing waste, abuse, or illegality, or whether we view whistleblowing as exposing to the public things that they might be interested in learning about, even if they're legal.
But just to follow up just a sec, I mean, I see that case as a lot less about whether he was a whistleblower than just kind of looking at every time somebody provides information to the public the government doesn't want, national security. And that opens debate about, are we better off by knowing things? Does that contribute to national security by making the public more aware of what the government's doing, or does it not? That to me is what the case is really about.
Well,
Could I just quickly add that one is, what else is there that Snowden has? I mean, what do you think he might? What other information might he have? And two, what evidence is there that he is curating any of the information that he is releasing?
So the government has said.
It doesn't know.
Was that?
That it doesn't know.
Well, no. Now they know. No, the guy who they appointed at NSA to sort of reverse engineer Snowden's disclosures now has said publicly that they're pretty confident they know what he knows. And what they've said publicly is that he's only disclosed 15% of the quantity of information that he has. I actually think that's misleading for a couple reasons. One, obviously you would disclose the sexy stuff first. And two, I suspect that by volume, a lot of the stuff Snowden has is actually specific individual classified communications. Right, that is to say, battlefield communications, encrypted communications between U.S. embassies overseas. I mean, the kinds of information that would add to the volume, but not the sensationality of it all. Right, that's to say, I suspect we have learned the really big programmatic stuff that we're going to learn from Snowden, with maybe one or two exceptions. I think the harder question is, who's the next Snowden, right? Because we all have a very short, the media especially has a very short memory. I mean, 2 years ago, we were having this conversation about then Bradley Manning, and about how Bradley Manning was responsible for the most damaging national security leaks in American history, and about how Bradley Manning had basically started this whole new trend and phenomenon. And Manning, we'd never have another Manning, right? That what Manning did was a one-time thing. Well, now Manning has receded into the historical ether as he serves his prison sentence at Fort Leavenworth because Snowden has overtaken him, right? And so I think there's going to be leaking. I mean, the ship of state is the only one that leaks from the top. Right? I think the question is not how can we stop the leaking. I think the question is there a larger problem of which the leaking is merely a symptom, to wit, overclassification, too much secrecy, insufficient transparency.
Well, I think that, but there's also sort of two more parts to that. One is the mechanism through which the leaks occur, which is the fact that somebody now can either put stuff on a thumb drive or on a disk, a CD drive, or whatever it
It's
is,
easier.
and they can walk out
As opposed
with,
to Daniel Ellsberg with the mimeograph
with,
machine.
yeah, I mean, it's not, clearly somebody would have noticed if they were walking out with, briefcases of information, right? But so the fact that they can put it on devices, and so that really becomes, well, it is a security issue. I mean, one would have thought that after Manning, that the reviews that I would suspect were and should have been done to prevent against sort of that type of walking out the door with all this information, really, I think, is a story that's been underplayed. The fact that Snowden was able to walk out the door with all this information, I think, has gotten sort of far less attention, and I, for one, am very curious about what it is that the government is doing to prevent that, in addition to sort of all these other issues.
Great, let's take some more questions. I'm going to introduce Peter Kornblue, who, I don't know if you've heard of the National Security Archive. Peter, you might just take just a minute to say what the National Security Archive is and then ask your question.
All right, well, the National Security Archive, which is sometimes referred to as NSA incorrectly, the other NSA, is the antithesis of the NSA. Some people think we're the library of the Central Intelligence Agency or something, and in fact, we're one of the leading advocates in the city for declassification and for the public right to know and less secrecy. And this issue really is about secrecy and transparency, national security versus the public right to know, not just the interest to know, but the right to know what's being done in its name but without its knowledge. And of course, when you live in this town long enough and get to be our age, you realize that there are some things that the government needs to do in secret in order to advance the security of the country and the legitimate interests of all of us. But there's also a lot of things that it does and always does. This is the lesson. Always does when there's too much secrecy. The gravitation is towards an abusive situation or a situation in which the public itself would not support this if it really knew what was going on. And we have a little twist here in which Mr. Clapper, the head of this program, actually has now said, if we had kind of shared the broad parameters of what we were doing early on, when we started doing it, we wouldn't be in this situation. And we probably could have survived, and these programs would succeed, would have gone on and more or less in secret. So what I think is interesting is the cycles of secrecy. And we've raised the issue of Daniel Ellsberg. For the younger people in the room, all of you should see this brilliant documentary film called The Most Dangerous Man in America, which goes back to the whole issue of the Pentagon Papers, the whole issue of getting them out to the press. I mean, this was the kind of basic. In those days, we didn't have the Ethernet and thumb drives. We only had Xerox machines and newspapers. We didn't have the internet. And so when one newspaper was shut down by the government from publishing the Pentagon Papers, Daniel Ellsberg simply took the big Xerox of them to another newspaper, and finally to a congressman who read them on the floor of Congress into the Congressional Record. It's a great movie. Speaks to the issues of today. Out of that whole issue came the Church Committee, led by Senator Frank Church.
And
FISA, the intelligence committees, as we know them today, the structures that we have. But I have to throw in this little comment. There was a member of the House Intelligence Committee, Norman Mineta, who before he went into the Ministry of Transportation, I guess, minister, you used to work with him, Joe, I know, and he used to say, I'm on the Intelligence Committee, and the intelligence community, the CIA and the Pentagon, and the NSA, they treat us like mushrooms. They feed us manure and keep us in the dark. And I don't think that's quite the same today. I don't think that's what's going on today. But there is an element of filtration, of censorship, of being very careful what actually gets said to the committee, and less so with the committee chair people who get brought in more and more. And so you get back to a situation where when it becomes public and the public responds, then of course you have a number of representatives who who suddenly pay attention. But getting the information is not easy, and if you're on the committee, you have to remember, if you're on the committee and you oppose this, you can't say anything publicly. You can make your arguments there, and the higher-ups are going to say, well, we're working closely with the CIA and the NSA, and they tell us this, and we have to go with what they say. And then the discussion completely gets shut down. So you have these cycles of abuse, scandal, secrecy, and efforts towards transparency. And that's where I think this debate has got to be. It's got to be about weighing our national security interests in a 9/11 world, where there obviously are real threats to our well-being and our society, against our right to know and what we want our society to look like. It's not just a right to know for the right to know. It's we don't want to move towards give the mechanisms to the government that are unchecked, and so we push for more transparency and more openness.
I think that's a comment.
Yes.
We have questions right here and right here. And
My name's Garrett. I'm a 2L at Washington College of Law. I have two real quick points. First, for Professor Wladek,
yes.
you make the move from the Intelligence Committee had access or was only able to access this information hidden in a drawer in a room, and you get there by saying, we were not briefed on this. I would like you to justify that move. And then second, you each suggest a lens through which we should view Snowden and his actions, one being moral and the other being kind of this whistleblower idea like Ellsberg, and I kind of think those converge at the point where Ellsberg turned himself in, was indicted under the Espionage Act. Snowden ran away to China, and I think those two different actions kind of play into the whistleblower mechanism and the morality of the leaking, I guess.
Good question. Yes, ma'am.
Yeah.
Who are you? Stand up.
I'm Tina. I'm in the Washington semester program, and I just wondered because one of you said that U.S. might be less secure right now, but there was actually some Norwegian politicians who nominated Snowden for the Nobel Peace Prize, saying that the actions, like after he had leaked his information, that the discussions and the policies that have been made after that has made the world a safer place. So, what do you think about that?
Very interesting.
My name is Carl Weichel. My question is regarding any culpability with regards to the press with our First Amendments, because ultimately it's the press that editorial board has been singling out what stories to release, and I'm sure there's more that may strategically come in the future. But the Guardian, the Globe, and the New York Times were hand-selected by Glenn Greenwald. If Greenwald would have gone to Fox News, PBS, and they disclosed the information, would they still have that same veil of protection that our black and white, long-established print media has?
Good question. It's a silent table? What's going on over here? All right, come on. Ian. We got a question over here. And I'm gonna gather all the questions because we bring the curtain down at 1:30.
Yeah.
So.
Okay, so quickly, fascinating discussion.
And who are you, Ian? Who are you?
Okay, my name's Ian Guest. I'm an adjunct at Georgetown, so I'm very pleased to see a compatriot up there. I'm also British, as you can tell, and I'm a former journalist for The Guardian, so this whole debate is very interesting to me.
So it's all your fault.
Well, I'm proud to claim responsibility, so I appreciate your question. By the way, Edward Snowden has just been elected the rector of Glasgow University. I don't know, maybe apropos of yours. So maybe we're just weird over that side of it. But I think this is a great question about the media. When I used to get secret documents, I found it my obligation to publish them. Anything with secret on it had to be published. Now, whether it was or not was usually the editor's decision, and thankfully the editor usually said yes. So I would also reiterate this question, to what extent do you feel the media is responsible in this? Do they have a responsibility? And should they be held to a standard, and if so, what? I mean, I'd agree with the Duke of Wellington, publish and be damned, because that's something, I'm a journalist, a former journalist, Another comment, Carrie, I mean, you're asking us to have confidence in the government to maintain a whole apparatus of secrecy and to keep secrets in our interests. And, you know, after the last 10 years as a human rights person, I don't have a huge amount of confidence, not just in this government, but in my own government in Britain, which is now trying to put a lot of heavy-duty pressure on The Guardian. I mean, look what's happened. Look what's gone down under the aegis of security and secrecy. Look at the WikiLeaks. You know, look at some of the stuff that came out in those cables. The helicopters that were shooting down Reuters correspondents in Iraq. Nobody ever got punished for that. There was no, as far as I know, no public investigation. Nothing. So you ask us to have confidence in the government to maintain secrecy in our interests. I think the burden of proof is on you to show that you should maintain that secret, that whole apparatus. So I mean, I think this is a great discussion. I applaud you both, and you know, certainly Joe, thank you for opening it up and giving us this opportunity.
And about this discussion, you'll notice in front of you, evaluation form. I'm part of Campus Life, and we have to fill these out. So if you have to leave, you can't leave before you have to fill this out. And we have about another 9 minutes of program. So please, before you leave, take them if you're going to leave. Otherwise, I'm going to give you a minute at 1:30.
Should we go quickly and then maybe one more round of questions?
If we can go quickly.
Sure. I think we can do that.
Can I add just one real quick thing because it's really
Jeff,
clear
yes.
that-
And Jeff, who are
Hi,
you?
Jeff Bachman, Human Rights Professor and SIS Director of Ethics, Peace, and Global Affairs. I wrote a piece a while back about whistleblowers versus leakers also, and the New York Times is never questioned about using anonymous U.S. officials who leak, authorized leaked information.
Right.
And so I think that's another part of this also is the government likes to, put information out there that reflects favorably on it with no accountability, but then Snowden releases things that it doesn't want released, and then there's all these questions about accountability.
So I'm gonna go first because Carrie, I think, has more to say than I do, or at least better things to say. So let me take the press on the last point. There's actually a fantastic. People are down on law review articles these days, but there's actually a fantastic article in the Harvard Law Review from late last year called "The Leaky Leviathan" by a Columbia law professor named David Posen, who's also a friend of mine, but don't hold that against him. And it's all about this problem, which is the incongruity between authorized leaking and unauthorized leaking, and whether the government actually makes it harder to take a hard line on unauthorized leaking because of how much authorized leaking goes on, and indeed how oftentimes the line between authorized and unauthorized leaking is very blurry, if not altogether illusory. As for the press, I think it's really remarkable that it's the British who are so in front of this, because England does not have the same tradition of First Amendment speech protections that we do. England has something called the Official Secrets Act, which is probably, which I think would be intolerable in the United States. And yet at the same time, there's, I think, much more, how shall I say, assuredness on the part of the British press when it comes to the importance of publishing these issues. What protects the New York Times from being prosecuted for publishing these disclosures on their front pages? Popular opinion and nothing else. The Espionage Act, the statute I mentioned before, quite clearly could be applied to anyone who even receives national security information they're not entitled to have. If I download a WikiLeaks cable onto my laptop, I am technically violating the Espionage Act. Now, the government, in its wisdom, has never prosecuted a media organization for publishing classified information. In the whole history of the Espionage Act, there's only been one prosecution of someone who wasn't already in the government, of a recipient of information as opposed to the leaker, and that prosecution fell apart, partly because of First Amendment issues, right? That there were serious First Amendment questions. But realistically, the line between the leakers and the leakees is as much about popular opinion and government discretion as it is about deep legal principles. I think that's part of why you see The Guardian, The New York Times, The Washington Post actually exercising some modicum of editorial discretion, because that, I think, allows them to feel more confident that they will prevail in the court of public opinion if and when it comes to that. We may forget this, but when the New York Times and the Washington Post broke the story of the TSP, the warrantless wiretapping program conducted by the Bush administration, one of the things we learned was that they had been sitting on that story for a year. right? That they had actually had the story for a year, that they had not run it, and that they had waited until they were relatively sure that there would be no immediate harm to specific individuals by publishing the details of this program before they ran it. So, I actually think the legal infrastructure is not nearly as important to the conversation about the press as the sort of view that the press is acting responsibly. And I will say, I think there are certainly folks who have been very critical of the press for how they've handled the Snowden revelations. I think for the most part, they've come out rather well. That is to say that I don't think the press is held in much less esteem today because of the Snowden disclosures. And just to sort of to one more sort of point in that regard, I think it's telling. There's a very important case before the Supreme Court right now about something called the reporter's privilege, about the right of reporters to not disclose their sources. And the reporter in question is a reporter for Fox News. Right? So the politics of this are not as straightforward as we might think. So on the press, really quickly on sort of Garrett's two questions, and then I'll turn it over to Kara to deal with the Nobel Prize piece of this. Although I will say, I think Hitler won the Nobel Prize once too, so maybe that's not in like 37 or 38, right? Wasn't there, I don't know. Anyway, so maybe that's not there was one, maybe it wasn't Hitler, but someone really bad won the Nobel Prize in 30, was that? No, in the 30s, there was one, anyway, whatever, okay. This is why I don't do poli-sci. I'm a lawyer, I just talk about statutes. So, Garrett, my point about what the intelligence committee had access to, I'm not making logical leaps. I'm just retelling what Congressman Schiff has said. Right? Congressman Schiff is not the only member of the House Intelligence Committee who has expressed concerns about what they had access to and when. But I think it's telling that there are members of the intelligence committees themselves, and not just members who were not privy to that information, who feel like they were inadequately briefed. Now, the response could be they weren't doing their job. That was indeed what Chairman Rogers said to Congressman Schiff on the record. But I think that's worth more exploration. I think when a member of Congress says that on the record, it's worth figuring out why they feel that way. As for Ellsberg turning himself in, I think it's important to note, though, that, Ellsberg, whistleblowing wasn't going to work in his criminal prosecution, right? There were no defenses that were available to him in a criminal prosecution by virtue of the fact that he thought what he was doing was right. Maybe there was jury nullification, right? But at the end of the day, the reason why the Ellsberg prosecution fell apart was not because of some great popular sentiment that Ellsberg was a hero. It was because the prosecutors committed misconduct. Unrelated, right, to the specific charges against Ellsberg. So I'm not as sanguine as you that Ellsberg is a sort of case of the right way to do it. I think if the prosecutors hadn't botched that case, Ellsberg would be in federal prison today.
Carrie,
if I can respond real quick, I agree, and my question is more about the morality of that, right? Like owning up to, I broke the Espionage Act, I did it.
If I'm not mistaken, Dan didn't step forward and say, I'm the leaker. I think he was identified, and then he...
That's right.
And he didn't...
Right, whereas Snowden said I'm the leaker. So again, I'm not trying to take a bottom line on the morality question. I'm trying to say I think we all will keep our own counsel about how we weigh the different factors and figure out whether we agree with what Snowden did. That's all I'm saying.
And Carrie has the last 3 minutes.
Okay, 3 minutes. Ooh, tall order. Well, here's sort of a couple concluding thoughts, I guess. First, part of the reason that I emphasize the role of the legitimacy of the congressional oversight and the role of the FISA Court is because those institutions were established with the express purpose of providing oversight outside of the agency that's doing it itself. So some other check on what they're doing. If we're at the point where the public says, well, we don't have confidence in any of those institutions anymore, then I guess the question that I would pose back is, well, then what is the alternative? Because the alternative cannot be, we conduct all of our foreign intelligence activities in public. Because if that's the case, then you might as well take the billions of dollars that are spent on the intelligence community and put it somewhere else, because they're not going to be able to do their job. There are simply some things that can't be made public in order to be done effectively. And collecting the communications of foreign terrorist organizations or individuals involved in cyber warfare or foreign nations involved in that, or the proliferation of weapons of mass destruction, or even the conduct of foreign affairs, which everybody in the recent debate acts surprised that that's part of foreign intelligence information. All of that can't be done in the public arena and be effective. So a lot of times, and Steve and I have been on other panels where this debate is not framed as sort of the Snowden issue, but it's framed in the bigger debate of, you know, privacy versus security. And that really is, I think, a false choice, because what the United States government is trying to do is to do both. You can't have a degree of, you're not going to have privacy, I guess, and sort of what we're all trying to protect in terms of privacy, if the government isn't providing a legitimate degree of security as well. And so what the government's trying to do is to do both. It's trying to provide security with a reasonable degree of the privacy that we come to expect as Americans. Whether or not we sort of have that exactly right, I think is, you know, what folks are talking about in the current debate. But the idea that that all of these institutions are not legitimate anymore, and that the American public has the right to know everything that the intelligence community is doing to protect it, simply is inconsistent with the business of conducting intelligence. And so that's why I think the task of today's government, which I'm not in anymore, is to figure out the best way to rebuild the confidence in our existing institutions. So in the court, in the congressional oversight, in the internal executive branch processes that conduct this oversight.
Great. I want you to do two things. All right? The first is join me in conveying our enthusiastic appreciation